Today we're going to talk about workplace harassment prevention from a management perspective. And let me start by saying that today's class is very much from the perspective of what managers need to know. I know sometimes people attend webinars with the intent of utilizing what they've learned to deploy training within their own organizations, and that is wonderful. I would just like to state very clearly that this is not the approach to take when you're doing harassment prevention training with your employees. This topic is very different when directed toward managers versus directed toward employees. Employee training is focused more on what your policy is, what is and is not acceptable, making sure they understand the types of things that represent harassment, workplace harassment that is legally defined, as well as other, professionalism implications and what to do if they feel they're harassed or discriminated against. And that's about the extent one would go with training their employees. This is a very different perspective. Managers need to know those things, but they also need to know what their responsibilities are as supervisors and how liability is created for their organization. So this is a much deeper dive into the compliance and navigating compliance associated with this very complex topic. And of course, we are focusing on anti-discrimination, anti-harassment laws specific to the U.S. in this particular program. And in the U.S., there are a number of laws that are associated with anti-harassment as well as anti-discrimination. Actually, all of the laws are anti-discrimination laws because harassment, by definition, is a specialized form of discrimination. And all of the laws that address anti-discrimination, anti-harassment grouped together, they're referred to as the family of equal employment opportunity laws. And these laws all prohibit employers from negatively impacting employees with regards to terms and conditions of employment on the basis of what are called protected characteristics. And we will explore what all of those characteristics are from a federal perspective. But when I say that you can't negatively impact employees, that means employees are protected against negative or differential treatment with regards to all terms and conditions of employment, including, but not limited to, things like firing, demoting, denying access to employment, denying access to training, harassing, or otherwise doing things that would be retaliatory against individuals on the basis of protected characteristics. And a few things that as a manager or an HR professional, because certainly this is a topic that HR professionals need to be knowledgeable about and really even need to have a deeper understanding of this complicated area of compliance than managers even. But managers and HR professionals need to be crystal clear on the fact that when we talk about protected characteristics, that is exactly what it means. It's the characteristic that is protected, not minority status. A lot of times I'll hear managers say things like, "Oh, be careful what you say to her. She's a woman. Women are protected." Woman is not a protected characteristic. Sex is a protected characteristic. People can't be treated differently or negatively on the basis of their sex, whatever their sex is. The protection does not apply to what is or is perceived as the minority in the population or any particular workplace. It would be just as unlawful to deny access to promotions to someone because they are a man as it would be to deny the same to someone because they are a woman. And it's very important to know that there are a few of the protected characteristics that truly are classes, which means some people are protected and some people are not. Age, for example, is a class. Under federal law, age protection starts at 40. Some people are over 40, some people are under 40. People who are under 40 under federal U.S. law cannot experience age-based discrimination because they're not in that protected class. But everybody has a sex, everybody has a national origin, everybody has a race, for example, and there are 11 federally protected characteristics. We will look at all of them. So these anti-discrimination and anti-harassment laws, they also don't say that people need to be treated better because of a characteristic than others. No, and that's a common misperception. Oh, I have to give preference to. I have to be careful with. No. What the laws say is that people are to be treated without regard to protected characteristic status. When you are determining whether or not to hire someone, you should base that decision on factors relevant to whether or not they can perform the job. And whether someone is male or female, what someone's national origin is, in almost every situation, has no relevance to whether they can perform the job. So those decisions have to be made without regard to protected characteristic status. And if we were all in a room together for a live training session, I would ask you all, what does without regard mean? And wait for you to respond. And usually when I ask that question, people just sort of look at me like I've, grown another arm. And because what does without regard mean? I mean, the answer is in the question. It means without regard. Without regard means without regard. Protected characteristic can't enter into employment-related decisions in any way, shape, or form. Nor should it affect how we refer to people, how we communicate with people, how we treat people in the workplace. If I'm your employee and I do a good job, say, way to go, Mary, you did a great job. Don't say, way to go, Mary, you did a great job for a girl, or way to go, little lady. That's not treatment that is without regard. Same thing as if you said big fellow or whatever term that some people truly think those terms are complimentary, but the reality is that the intent doesn't matter. Without regard means without regard. It should not enter into the workplace. And here's where your responsibility as a supervisor kicks in, because people do and say all kinds of things to each other at work that they clearly do associate with protected characteristic. And when the supervisor becomes aware of that, it's important for you to recognize that it's an issue and put a stop to it. And failure to do that creates, or even exacerbates, I should say, liability for your organization. And so it is unlawful to use any kind of protected characteristic information to make any kind of employment decision, with the exception of those situations which truly constitute legally defensible bona fide occupational qualifications, and those are few and far between. And it's also important to note that supervisors and the companies in which they work can be liable for workplace harassment even if they didn't know about it, because the Equal Employment Opportunity Commission, which is EEOC, and the courts use a standard of should have known. Hear me clearly when I say that if an investigation reveals that it was openly practiced or widely known, if everybody heard my manager consistently referring to me as little lady or good for a girl, and that's just part of the culture and part of the communication, well, that represents a pattern of hostile environment harassment that is openly practiced and widely known, and management can scream, we didn't know, all they want. But if all the other employees are aware of it, and, when an investigator says to them, what kind of thing, how does your boss congratulate you? And that's the language that gets conveyed to them, that liability is going to be there. You can scream, didn't know, all you want, but if it's part of the culture, if it's part of how people interact with each other, should have known is going to apply. And as far as the EEOC is concerned, it is a responsibility of the organization to ensure that managers know their responsibility. And I would imagine that that's probably the reason why some of you are in attendance today. So this is all tied to a complex legal environment related to equal access to employment that can be traced back to 1964, when the Civil Rights Act went into effect. In the United States, this was the first piece of legislation focusing on equal access to employment, and it defined 5 characteristics as protected, which means these are 5 characteristics that people can't be impacted in terms of access to employment or any terms and conditions of employment on the basis of these characteristics. Now, some of you may be thinking, wait a minute, you said that there are 11, and that's right, there are. As of 1964, the first 5 were defined, and the other 6 have been defined through additional legislation since then. Civil Rights Act is not the only equality-focused legislation in the U.S. So the Civil Rights Act defined as protected. Race, national origin, and ethnicity are defined together. Color, sex, and religion. Everybody has a race. Everybody has a national origin and an ethnicity. Technically, they're different things, but for all intents and purposes, this means where you came from in terms of ancestry back to the beginning of time. Your national origin is the country in which you originated, you were born. Ethnicity is ancestry all the way back. Everybody is a color, has a shade, has a skin tone. This applies specifically to skin. Everybody has a sex, and everybody either, we live, as far as religion goes, people either have a religion or they don't. And they have a constitutionally protected right to be any religion they want or no religion at all. People can't be treated differently because of what their religion is or isn't, can't be put down or denied access to any terms and conditions of employment. And this doesn't apply to mainstream religions because, again, no establishment. That is part of the Constitution of the U.S. There's no establishment of religion. So, and sometimes issues arise with that, when people get into their minds that it's okay to be any religion you want unless it's X religion or Y religion, whatever that may be. And employers don't get to decide that. We don't get to decide what is and is not a valid religion. So that was the first 5 protected characteristics. And once the Civil Rights Act was passed, that set in motion a chain of events that led to additional laws related to equal access. And I want you to hear me very clearly when I say equal access. Do not ever let the phrase, quote, reverse discrimination come out of your mouth, because there is no such thing. The characteristics are protected. Every race is protected. Every religion is protected. Every national origin is protected. Every sex is protected. Every color is protected. You can't treat people differently or negatively on the basis of any of these characteristics. Now, beyond Civil Rights Act, I mentioned the age earlier. Age is truly a class because age protection starts at 40. That protection was defined under the Age Discrimination and Employment Act in 1967. A little over 10 years later, the Pregnancy Discrimination Act came along and specifies that employers cannot treat people differently on the basis of pregnancy or any pregnancy-related condition. Anything associated with pregnancy is a point of non-discrimination. And what the law basically says is that you have to treat pregnancy the same as any kind of temporary circumstance that might impact someone's ability to do their job. You know, if I'm supposed to stand up at work, but I break my ankle and I need to sit down and you let me, then the pregnant person who needs to sit down, you need to let that person do it. You can't deny people access to employment based on pregnancy. And all too often in 2019, many, many years after this law went into effect in 1979, I'll hear managers and even HR colleagues say, we hired so-and-so, and can you believe she didn't even tell us she was pregnant when she interviewed? Isn't that awful? And I'm like, no, you can't ask her that. You can't use that information to make employment decisions. What difference does it make if she tells you or not? If she tells you and you choose not to hire her, you broke at least one law. I would argue two. I would argue that's a civil rights violation as well, because that would also be sex-based discrimination. It's not like people who weren't women could be discriminated against on that basis. Citizenship is protected under the Immigration Reform and Control Act. And before anybody starts yelling, no one is saying that you need to hire people who are not legally authorized to work in the U.S. As a matter of fact, it is unlawful for U.S. employers to hire, employ, or continue to employ people who are not legally authorized to work in this country. That's why we have to get I-9s from people. That's why many, many employers very wisely use E-Verify to ensure that the people they are hiring are who they say they are and who have the authorization to work in this country. But, and that's the same law, the Immigration Reform and Control Act also specifies that you can't use the fact that someone is not a citizen if they are legally authorized to work in the states. You can't use that as the reason to exclude them from consideration for hire. Military status and obligations are also protected. This applies to past, present, and future military service or obligations. So, some people are in or have been in the military and some people have not. So in that case, it's a class, but you also have to understand the future. Like as a manager, if you try to dissuade your employees from entering military service, which has happened, and the Veterans Administration has actually dealt with complaints related to managers telling employees that they shouldn't pursue military service, even those employees aren't in the military at the time that happens, that future is protected as well. But so that one is a class, but it's a little more complicated than it seems at face value. Disability is also a protected characteristic. The Americans with Disabilities Act was passed in 1990 and was updated significantly in 2008. Disability applies to physical or mental impairments that substantially limit an individual's ability to perform one or more of life's major activities with or without a reasonable accommodation. It's an extraordinarily complex area of employment law. The best advice I can give for managers related to disability is for any situation with an employee that you even think might be disability related, to get HR involved before pursuing the matter. But we can't discriminate against people on the basis of a disability. Now, and a common misperception there is that you have to hire people who can't do the job and then let them out of doing the job, and that is not the case. Reasonable accommodation means finding a way to make it possible for the person to do the job. And if there's not a way to do that, or if the way would really put the company in a situation of an undue hardship, then there's no obligation to do that. But you should tread carefully and you should seek legal counsel in such situations. The 11th protected characteristic is really genetic information, but what that means when we're talking about it in this context, things we can't harass or discriminate on the basis of, is a person's family medical history. An individual's own medical condition, that could be their disability, but something that runs in that person's family, that is genetic information. If you knew you had an employee who had a relative who had a condition with a genetic basis, we'll just say breast cancer, for example, and you decide, oh, well, I'm not going to promote her because this runs in her family and we know it's genetic, and so therefore we don't want to put her in that job because she might get sick and leave. That would be an example of discrimination and harassment based on genetic information. But so would calling somebody nicknames or picking on them about it. In the case of genetic information, even asking them to provide genetic information to you could constitute an issue. Like if an employee comes to you and says, my mother has been diagnosed with breast cancer, I need to apply for family medical leave to accompany her to medical treatments. Certainly you should express sympathy to that person. I'm so sorry to hear this. What can I do to help? How can the company support you? That's all fine, but you shouldn't say, oh, does that run in your family? Oh, what strain does she have? Because then you're asking for genetic information, and employers aren't allowed to do that. And a lot of times when I say that, managers will respond by saying, how dare you tell me I can't express sympathy to my employees? You can express sympathy to your employees. You can help your employees. You can offer support to your employees. You cannot ask them about genetic information. Does it run in your family is where it crosses the line. So that's all 11 of the protected characteristics. And managers should know what those protected characteristics are so that when things related to that enter into how people are treated in the workplace and how assignments are doled out, the types of things that people say to each other, so they have a sense of the types of things that are just flat out off limits. And it's even a little more complicated than that. Like you also can't discriminate on the basis of how people's opinions on unions. You can't discriminate on the basis of whether or not someone has a family medical leave circumstance on file. Those things aren't really considered protected characteristics, but they are important considerations to know when you're trying to protect your organization against discrimination allegations. So I know that's a lot of information. Something I would encourage you to do after the training is, you've got your materials that go along with today's session. Study those protected characteristics. Know what they are so that when they're introduced in the workplace, you can proactively take steps to shut that down so that the liability is mitigated for your organization, as well as to ensure that people aren't being disadvantaged in their careers on the basis of things that are legally protected, all of which are things that they can't help and or are constitutionally protected. So how does this apply when we're hiring? A lot of times managers are given this magic list of illegal interview questions. Don't ask these questions. And there are certainly things you shouldn't ask. But when I first started managing people, because I moved into HR through operations, I was given a list that had about 15, maybe 20 questions on it. I was like, don't ask these things so we don't get sued. And it said, don't ask how old they are. But it didn't say, don't ask how many years they've had a driver's license. Or don't ask how many years they've been in the workplace or things like that. And those are all questions that tap into age. It would say, don't ask what country they're from. But it didn't say, don't ask if English is their first language. Don't ask what language they speak at home. Those are all national origin questions. The real issue, there's no such thing as a list of questions that is sufficient for managers to know everything they need to know to protect the organization. Better, know the protected characteristics. Don't ask anything related to those topics. And if employees start telling you things related to those topics, stop them and reframe the question. Because the real issue is that it is unlawful to use protected characteristic information to make employment decisions. I didn't just say it's unlawful to ask. It's unlawful to use that information. And I used to think very, very early in my management career, because when I first became a manager, I hadn't had previous training specific to HR. I thought, oh, if somebody tells me, I guess I can use that information. No, if somebody tells you something related to protected class and then you don't hire them, you don't promote them, and they accuse you of using that information, they don't have to prove you did. You have to prove you didn't. And that's pretty hard to do, especially if it never crossed your mind to do it. So the safer option is to avoid getting such information. So we all need to know the protected characteristics, and we need to keep them out of the hiring process. We should never, ever, ever ask interviewees protected characteristic information in any way, shape, or form. And we should also avoid asking questions that are so open-ended that people are likely to share protected characteristic information. You know, a lot of people in interviews who are will just say, "Oh, tell me about yourself." Please stop. Please, please, please don't ask that. That is an invitation for them to just throw all kinds of protected characteristic information out on the table. And some people are going to do it because it's really what defines them, and some people are going to do it because they know that you've just opened the door to make it really, really easy for them to sue you for employment discrimination, and that's what they want. Don't put yourself or your company in that situation. So don't say, "Tell me about yourself." That's too wide open. You know, what if I say, "I like to bake cakes and I have 3 dogs"? I mean, how is that going to help you decide whether I can do a job or not? It's not. That is of no relevance to you. And what if I say, "I'm proud of the fact that I supported 3 people in my family as they fought XYZ debilitating disease, and I'm a single parent of 6 children, and I'm able to do it with very few absences from work, and I'm able to do it because of the support I get from my church family, and I go to church here and there." Well, that is like a multi-base harassment lawsuit looking for a place to happen if you don't hire that person, because you'll never prove that you didn't use that information to make your employment decision. Or if you do prove it, it's going to be a long and costly road to getting there. So don't put yourself in that situation. Tell me about why you're interested in working in manufacturing. Tell me why you chose to leave this large metropolitan area where your last job was to move to this rural area. You're going to get to know them that way, but you're going to get to know them in the context of the job. Don't ask for stuff that you're not going to use to make decisions. And certainly don't ever ask for stuff that you can't legally use to make decisions. And if they start to give you protected characteristic information, stop them. Say, "Wait a minute, let me reframe the question. What I'm looking for is," and get that question turned around so that it is more focused on information that you really want to use. And of course, when you do make your hiring decisions, document those reasons. If they do accuse you of using protected characteristic information, then you're going to have to go back and try to prove that you did not. So you're going to need to be able to demonstrate why someone was selected over the other. And situations aren't looked at in isolation. You know, you're going to, if that accusation is made, the company's going to have to look for, show patterns. So again, keep that stuff out. And I run into some managers who think that they have to worry about all this stuff up through the interview process, but then once the employees are hired, that all that stuff doesn't matter anymore, and that's not true. Potential liability doesn't end with the interviewing process. It is a fact under U.S. law that in the workplace, people are to be treated without regard to protected characteristics. There are 11 federally characteristics. Many states have defined additional characteristics as protected as well. So you would need to educate yourself about any specific statutes that may apply in the state where you live. For example, in Louisiana, sickle cell trait is protected. In California, being a victim of domestic violence or stalking is a protected characteristic. And when people aren't treated without regard to protected characteristic, then the result, from a legal perspective, I'm not talking legally, the result is harassment and discrimination. Because like I said, harassment is a specialized form of discrimination, and the EEO laws have protections against both. So what is discrimination? And hear me clearly when I say, just because an employee uses the word discrimination does not mean that what the employee is describing is in fact discrimination. Discrimination is treating people differently on the basis of a protected characteristic. Sometimes I'll deal with complaints with clients where the employees, my boss is discriminating against me. She yelled at me and said that she would fire me if I was late to work again. Well, that might not be polite. That might not be the best way to handle employee behavioral issues, but it's not unlawful. Legally defined discrimination is treating people differently on the basis of a protected characteristic, and it applies to all terms and conditions of employment. Within the scope of discrimination, there are two forms of harassment. There is what's called quid pro quo, which applies specifically to sexual harassment. Quid pro quo is Latin. It means this for that, one thing in exchange for the other. It is the circumstance of typically it's supervisory subordinate in almost every situation where a manager would promise or threaten to deny or really give or really deny access to terms and conditions of employment on the basis of sexual conduct of any type. I'll do this for you if you do this for me. If you don't do this for me, I'll make sure you don't get what you want type harassment. And then there's hostile environment harassment. Hostile environment harassment can be sexual harassment, but it can also be harassment on the basis of any legally protected characteristic. Hostile environment harassment is defined as unwelcome comments or conduct, which of course conduct is behavior, based on any legally protected characteristic that unreasonably interferes with an employee's work performance or that creates an intimidating, hostile, or offensive work environment. And your standard of what is offensive, your standard of what is intimidating, your standard of what is hostile may not be applicable. The EEOC and the courts use the, quote, reasonable person standard. Could a reasonable person find this circumstance to unreasonably interfere with their work performance? Could a reasonable person see this as intimidating, see this as hostile, or see this as offensive? And when that is the case, then hostile environment harassment occurs. And the Equal Employment Opportunity laws prohibit both. They prohibit quid pro quo harassment and hostile environment harassment. We also have to be mindful that they prohibit retaliation, which we'll talk about in a minute, but there's also protections against what's called third-party harassment. Someone who may be themselves, they're not the target of the harassment, but they have to be exposed to it in order to do their jobs. This is harassment of employees who are not they themselves the target of the behavior. And it can occur in quid pro quo situations. It can occur in hostile environment situations. In quid pro quo, say there's a situation where the manager tells an employee, if you sleep with me, I'll make sure you get this promotion, and that employee gets the promotion. The other employee who applied, who was equally qualified, who either turned down the manager or was not propositioned by the manager, who didn't get the job, has experienced third-party harassment. They were denied access to an employment opportunity because of quid pro quo harassment that took place between that manager and another employee. And the flip side is true as well. Say the manager's already involved in a sexual relationship with an employee. This situation comes along. The manager decides not to promote the one he or she is in the relationship with, and so promotes the other employee. The one who's in the relationship might not be real happy when that happens and can scream that they were denied access to employment because they were in a sexual relationship with the manager. And yes, that still falls under quid pro quo harassment. It does not matter that if the relationship was consensual. What is unlawful is in any way, shape, or form tying the granting or denial of employment benefits to sexual conduct in any way, shape, or form between a supervisory and subordinate employee. any supervisor who's involved in a relationship with someone in their reporting authority is putting themselves at risk and is putting their companies at risk. And I know a lot of companies have policies that say that if you are in that relationship that you should disclose it to the company. And that's a good policy, but the fact that the company knows about it doesn't alleviate potential liability. Again, what is against the law is tying, granting, or denial of employment benefits to that type of relationship. A lot of the reasons companies want things like that disclosed is to make sure that that manager isn't in the situation of on his or her own making decisions that impact the path of other people's careers. So that's an illustration both of why supervisory, subordinate, romantic, or sexual relationships are dangerous and of third-party harassment in such a circumstance. Hostile environment harassment from a third-party perspective would occur when employees who are not themselves harassed, but they have to work in an environment where such harassment is pervasive. You say you have an open floor plan or cubicles, and one of the employees in the cubicles is, hey baby, and everybody, or showing people pictures of their body parts on the phone, or making nasty comments to people about their religion or their national origin, and maybe he's not talking to, or she's not talking to this one employee, but this employee is sitting there subject to it. They have to hear it to do their jobs. That's third-party harassment. So here's where I would ask again, what does without regard mean? Trick question. Without regard means without regard. These protected characteristic topics basically are ones that flat out do not belong in the work environment. And it's not because I'm trying to be sensitive or politically correct or whatever word you want to use. It's because there are laws that specify that they are not allowed in the work environment. Yet this continues so much. I was working with a group once that literally had been ordered by the EEOC as part of a settlement agreement or to put all of their managers through a harassment prevention training. And someone said to me in that class when we had the list of protected characteristics up, if we can't talk about those things at work, we won't have anything to say. And if that's going through your mind right now, let me just tell you, you are at extraordinary risk of losing not only an individual complaint, but a class suit, because every person in your work environment is being subject to a legally defined hostile environment. And I really don't like the phrase hostile environment because there's plenty of things, when you hear the word hostile, you think yelling, screaming, physical, but that's not what it means here. Hostile environment harassment is simply tied to treating people differently on the basis of protected characteristic. Hey there, little lady, pretty little thing, come over here, sit on my lap. Ooh, let me touch you when you go by. That is all hostile environment harassment, as is giving people nicknames that are associated with protected characteristic. If I worked with you and you knew me pretty well, you would probably know that heart disease runs in my family. I don't have it, but my father died in his early 60s, and both of my brothers had multiple heart surgeries before they were 40 years old. When I say it runs in my family, I mean it runs in my family. And so, say my coworkers decided to give me a nickname of cardiac arrest. It's not disability discrimination. I don't have it. But it is genetic information discrimination. It runs in my family. And if I go to work and am called that, I'm subject to a hostile environment. And I know a lot of times people are like, well, why would you care? Well, it's something that sometimes it upsets me to be mindful of that. You say that to me a day that one of them's in the hospital, how am I going to react that day? And then beyond that, say I apply for a job that requires me to climb up ladders, and work on phone poles or electrical out, and you're making that employment decision, and you're like, people call that girl cardiac arrest for a reason. Why am I going to put her in this safety-sensitive job? Well, then I've been denied access to employment for a medical condition that my siblings have that I don't even have. That is discrimination. So there are reasons the laws are in place. And when people get really invested in, but I should be able to, I don't know why people get invested in that, why you want to put people down on things that they have no control over and or are constitutionally protected, but you can't. There are laws that say you can't. They've been on the books for a very long time. The most recent of these laws is the Genetic Information Non-Discrimination Act, and it has been in effect since 2008, and it was signed into law several years before that. So I also mentioned that retaliation is prohibited. The Equal Employment Opportunity laws, they all have a no retaliation clause. Pretty much every employment law, even if it's not related to EEO, has a no retaliation clause. Sometimes the equivalent would be referred to as a whistleblower clause. But basically, you can't take a negative action toward an employee as a result of exercising a right that is protected under the law. You know, if your employee decides to contact OSHA and tell them that your work environment is not safe, whether it's true or not, you can't retaliate against them. The same applies. If they decide to call the EEOC and say that they are being discriminated against on the basis of one or more protected characteristics, if they file a complaint using your internal complaint procedure, because retaliation doesn't just have to apply to a statute. If you have told me this is what you should do if you feel there's a problem, and I do it, you can't, that is a protected activity. You can't retaliate against me for it. And retaliation involves three elements. It's a protected activity. I file a complaint. It's an adverse employment action. You fail to promote me. You demote me. You put me on a worse schedule. You change me to another location that doubles my commute. You pick on me so that my coworkers shun me and think I'm a tattletale. I mean, the list could go on, because an adverse employment action since 2006 has been defined as anything that would negatively impact terms and conditions of employment. And then, of course, a causal connection, that the cause of that adverse action was the protected activity. Like if I file a complaint with the EEOC the day after you've caught me embezzling and you fire me because I embezzled, that's not retaliation. You didn't fire me because I called the EEOC. But you also can't create pretext, and something that comes up after the adverse action isn't going to protect you against the allegation. So when I say this is complicated, I mean it. It's pretty complicated. And some key terms that we all need to know as supervisors or as HR professionals, two of them we've already touched on. That reasonable person standard. It's not, does Mary find this harassing, but could a reasonable person perceive this to be? And should have known, we've talked about, and I've been in a suit when, as a manager, because of something employees did, I've seen a lawsuit that had allegations of negligent hiring, negligent retention practices, and the allegation is that you should have known that this person's past was an indicator that the individual could pose a risk to others in the workplace, and you have to be able to show what decisions you made to try to show that you weren't negligent, that you didn't have any way of knowing that, or those situations where it's, most workplaces have somebody in HR is walking around holding their breath, just waiting to get served a lawsuit, because they're always touching people when they talk to them, or making little comments that they think are cute that are across the line. And those are the things that should have known bites you with, because if you knew it was happening and you didn't stop it, that is much worse than finding out it happened and putting a stop to it immediately. It's also important to know we're talking about civil law here. I mean, certainly workplace harassment situations could cross the line into criminal situations, but most of the circumstances we deal with in the workplace are civil law, and intent doesn't matter. It's without regard means without regard. I just meant it as a joke doesn't mean it's okay if there's a law that says it can't be in the workplace. Period. End of story. But you can but all day long. Intent doesn't matter. And I've done a number of internal investigations, both as a within my own organization, places where I had worked in the past before I had a small business of my own, as well as for clients. And I can't tell you how many times the manager will say, um, that the manager will say things like, well, it was just a joke. I was just kidding. I thought it was funny. I thought it was cute. Um, it doesn't matter. The issue is if it happened or not. And let go of it. I mean, if it doesn't mean something to you, just stop doing it. Intent doesn't matter if it happened or not. It was just a joke, or I thought it was cute, is never a defense when there's a law that says without regard. And you also have to keep into consideration that burden of proof, the on who to what standard. It's not up to the employee who accuses you of proving that it happened. It is up to the employer to prove that it didn't. And if you work with an HR person who's always like, where's the documentation? Did you write it down? It didn't happen if it's not written down and the employee didn't sign off on it. That's part of why they're asking for that, because when you're saying, oh, no, I didn't fire this person because they called the EEOC, I fired them because their performance is horrible, and then HR goes and opens their file, and they see that performance evaluation, and it says perfect, 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 perfect. If it's not written down, it didn't happen. That performance evaluation that doesn't document what you are now claiming are performance problems is basically evidence for the employee that you had no reason to take that action. So I know it's a lot to think about, but I'm going to give you a little more to think about, talk about how commonly this occurs. Does this stuff really happen? Yes, absolutely. Harassment and discrimination do occur in the modern workplace. Sometimes it's intentional, sometimes it's unintentional, but the reality is that it doesn't matter if it was intentional or not. And it's also true that people sometimes file false complaints. I know it. I've met some of them. Sometimes, what's a false complaint really was just a misunderstanding. Sometimes it's, I caught this company letting something happen that they shouldn't let happen, and I'm going to get paid. Sometimes it's very malicious. But the reality is that if the workplace is truly beyond reproach, the person with malicious intent is not likely to be able to come up with something that's going to stick, that they're going to succeed with. But the harsh reality is that most companies have what they think or just ignore are so-called little things that occur that end up building that case that helps create a situation where it seems more likely than not that the accusation the person has made has stuck. So basically, if there's no ammunition, that person can't come after you, or at least that person doesn't have a chance to be successful. So you want to make sure that without regard applies in your work environment. So how common are discrimination charges? These are numbers from fiscal year 2017. The last time I checked, the 2018 numbers weren't out yet because of the shutdown. They may be available soon. When they are available, or if they're there now, they would be on the EEOC.gov website. I have seen some preliminary numbers for sexual harassment complaints, charges filed in 2018, and I can tell you they spiked very significantly in 2018, but these are the approximate percentages by type of the charges for that year, and of course these percentages add up to more than 100% because a single charge can have more than one base. If you're, we don't want any little ladies named cardiac arrest, that's sex discrimination and genetic information discrimination. And a single charge can have multiple. And retaliation doesn't just apply to the person who filed the complaint, because, of course, when a complaint is raised that might have policy, procedure, law implications, the next step is totally forgot what I was saying. The next step, once somebody files that, is to conduct an internal investigation. And during the course of that internal investigation, someone with the company or a third party is going to end up interviewing witnesses. And witnesses, anyone who participates or assists with an investigation, is also protected against retaliation, and so they can charge as well. So back in before the end of the year, before the end of 2018, the EEOC published a news release that had preliminary sexual harassment specific stats in it, because of course there's a lot of attention on sexual harassment now in the age of Me Too and Time's Up, with so much media attention focused on very high profile sexual harassment cases. I felt that it was going to lead to an increase, and that did come to pass. The government's fiscal year, federal government, runs September through October. And for the fiscal year ending October 2018, there was a 12% increase in charges that include sexual harassment as a base over the previous year. And even more significantly than that, the stats had been almost constant, no statistically significant difference for a decade. And last year, with all this attention focused on this topic, there was a 12% spike. So if people are not waiting to file complaints, stuff that people would have put up with before, they're not putting up with anymore. And of course, people who are looking to make a quick buck may be coming faster and faster too. Time will tell if that is the case. But also during the last fiscal year, the EEOC ended up recovering, meaning ordering employers to pay around $70 million out to people who experience sexual harassment in the workplace. That's through both administrative enforcement, which is investigating you as an individual organization, or they also have the option to either file suit against your company in federal court on behalf of the person who complained, or to seek out a class if multiple employees were affected and file a class action suit in federal. And the year before, the total was $47.5 million. 47.5 to 70 million. That is a big, big, big difference. There weren't that many more settled. And during that year, that they also filed 66 harassment lawsuits, 41 of which included allegations of sexual harassment. So there was more than a 50% increase of the EEOC filing lawsuits alleging sexual harassment. So these stats are all separate from the fact that once the EEOC is done with you, the employee can go after you in court in your geographic area. And these numbers also don't include legal fees. So protection and prevention is key. So some key facts and outcomes. We're back to that fiscal year 2017 now. During that time frame, the EEOC resolved over 99,000 charges, handled well over 500,000 phone calls, over 150,000 inquiries in person in their field offices, and secured over $484 million for victims of discrimination and harassment in the workplace. Filed 184 merit lawsuits, 124 on behalf of individuals, the rest class. And when the EEOC goes to court, the EEOC wins. They had a favorable result in 91% of the cases that were heard through the courts that year. And they're very focused on reducing the charge workload. They're working on not dragging this stuff out, faster investigation, really prioritizing filing in court if it makes sense to do so, and also improving their digital systems, which improves their efficiency as well. So if you've ever thought this stuff doesn't happen, yeah, it does. They're very costly. $48 million in fiscal year 2017. This spike I expect for 2018 includes, like I said, it's only monies ordered through EEOC, but it's only the beginning. It doesn't include legal fees. It doesn't include action beyond the EEOC. And we'll just sort of move toward wrapping up with a little quiz, and here's a hint. The answers are all false. These are common misperceptions. These are all things that I have either seen in my work or been asked in classes. If a person doesn't complain about being sexually harassed, the company cannot be held legally responsible. That is a big misconception. I know your policy probably says if you feel you've been harassed or discriminated, you should tell your supervisor, tell HR, tell this other person. Well, sure it does. But if they fail to do that, it doesn't mean that it didn't happen. The liability is still there. As a manager, if you don't know an employee is being harassed, you cannot be held legally responsible. Yes, you can. Should have known. If you were paying attention to what was going on, would you have been aware of what was going on in your work environment? That's basically how it plays out. And employees will go pretty hard or try pretty hard to hide stuff from managers. You know, we've got to be diligent in managing that work environment, being mindful of what's going on in the work environment. The next false statement, if someone participates in offensive behavior, the person cannot claim that he or she was harassed. That is not true. Just because you have done something you shouldn't doesn't mean that people have a blank check to do things that they shouldn't to you. This next one, there's case law on this. It's legal for a manager to promise an employee a promotion in exchange for sex if the employee is really going to get the promotion anyway. No, that is not true. With quid pro quo, a single incident of a threat of tying, granting, or denial of employment benefits to sex in any way, shape, or form is sufficient for liability, period. Next false statement, an employer can't be held liable for the actions of a supervisory employee acting beyond the scope of his or her authority. Yes, the company can. If they tell you not to do something as a manager and you do it anyway, you're responsible for your own actions, but the company still has liability too because they've put you in a position of being a manager in that organization. And the reality is that employers are always responsible for the acts of their agents and their supervisory employees with respect to legally defined workplace harassment, sexual or otherwise, regardless of whether the specific acts completed were authorized or even forbidden by the employer, and whether the employer knew or should have known of their occurrence. So what does that mean in plain English? If, as a manager, you engage in sexually harassing behavior or other types of workplace harassment, the company is still liable, even if they have a policy prohibiting it, and even if upper management had no clue, not even should have known, no clue, because you're in that position. Companies can't afford to keep managers around who insist on engaging in harassing behavior or refuse to stop harassing behavior. And with quid pro quo, when there truly is a proven quid pro quo claim, it really did lead to that tangible employment outcome, literally there is no way to mitigate that. The courts use a strict liability standard there. If it didn't lead to a tangible outcome, the employer would still be liable unless they could prove both that they truly did exercise care to correct and prevent and remedy the situation, and that the employee unreasonably complained to management or avoid harm. And those I've already mentioned about the threat of economic loss. What a big deal that is. There's no room in the modern world for managers to attempt to tie employment benefits to sex. With hostile environment and liability, employers are liable if they knew or should have known about the harassment and failed to take corrective action. And anyone can create a hostile environment. It can be your supervisors, your employees, even vendors working at your location could create a hostile environment. And again, just to make sure that's really pinpoint focused in your mind, what does should have known look like? An employer may have been expected to know about the hostile environment if there was a complaint to management. And when the person complains, they don't have to use the word harassing. They don't have to say, I feel that I'm being harassed. It can be the person who's in here working on our copy machine called me and then gives you a racial epithet. Well, that's harassment. Don't say, well, they don't work for me, just go over there and do your job and ignore it. That's you knowing there's harassment and telling the person that they have to put up with it. Exacerbated liability at that point. Also, look, if management doesn't have a policy against harassment, if your company doesn't have a policy, you need to get one. And if you have one, you need to ensure that it is effectively and frequently communicated to employees at all levels. It is a best practice to do workplace harassment training with managers and employees every 2 years and to redistribute the policies at that time and have them sign off on them and put those updated sign-offs in their files. And then, of course, if it's something that everybody kind of knows about. So as a manager, you need to put a stop to harassment, get HR involved. When a complaint is made to you, if you see or hear about behavior that may be offensive to others or that you know represents sexual harassment or other forms of workplace harassment, if you should be aware, if you yourself engage in harassing behavior, if you delay in taking action. Problems don't go away if we ignore them. So if you delay or if you fail to take action, or if you take retaliatory action towards someone who filed a complaint or participated in an investigation. So there's a lot of liability. There's a lot of ways liability is created. Prevention is the best defense. Stop it. If there's things going on that shouldn't, stop them. If an adverse action related to quid pro quo took place, there is no defense. If the existence of a hostile environment is established, that employer liability is also going to be automatic unless the employer took action to prevent and remedy the harassment, which would include starting that internal investigation within 24 to 48 hours of finding out that there may be a problem, and if the situation warrants, potentially separating people or removing not the person who complained, but others from the work, people who may be doing things they shouldn't from the work environment, pending the investigation. And, of course, if the employee failed to act reasonably to avoid the harassment. So this is a very complicated area of compliance. Follow your company's complaint procedure, whatever it is. If you don't have a clear one, talk to your HR team or owners, managers, depending on the size of your company. There needs to be a procedure. And managers shouldn't try to investigate their own employees. Someone who is not in their direct supervisory authority, who knows employment law, should do that. Managers are sometimes involved in investigations, but generally not. Managers have to listen to complaints objectively, make sure the procedure is implemented, and again, if you don't have one, talk to your leadership about getting that put on your to-do list, maybe bring in legal counsel to assist you with that. Immediately report complaints related to policy, procedure, law violations, but let HR take the lead, and of course, you're want to make sure there's no retaliation taken. I know that is a lot of information.